Okay, so let's start with looking at the business structure itself. It may be the case that you've thought of an idea, you've had some meetings with a co-founder, and you think there's something there that is a business and is going to make money. Fairly early on, you need to make a commitment that you're going to set up a company through which to conduct that business. And the main purpose of doing this is that the company will be the first line of defense. If something goes wrong, someone's injured, someone's property's damaged, it's not you personally that is going to suffer, but it's going to be the company. Being a sole trader, which is what a hairdresser might do, or a owner of a coffee shop, is not appropriate for the sort of business that you will be creating. At a very basic level, you need to have a separate legal entity that will own and run your business and be responsible for any claims that are made. This is really the fundamental building block of your business, and if you don't get this right at the start, it can prove costly to change later on. To me, if a founder comes in and hesitating about whether to set up a company, then I think there is some fundamental doubt about the business itself. So once you've made that decision to go, get a company. The next question then is, what sort of company do I need? For most of you, I think this will be a private company. This type of company is what most businesses run through, and it's private because it's not listed on the stock exchange where the public can buy and sell shares. But it does mean that at the end of the year, if you've earned more money than you've spent and there's a profit, you can either keep that money in the business and invest it in next year, or you can take the money off the table and give it to yourself. And so that's why most people who are in business do so to make money and to provide for their families, and so that's the most common structure. I know in this Catalysr environment though that there are some people who come with a goal of a for-purpose enterprise. These are still a company, but a different type of company. And by that is an enterprise which is doing good and where the money is going to be ploughed back into the business, only back into the business, or is going to be passed on to people who may otherwise not have sufficient funds for themselves. So with these type of companies, which are called companies limited by guarantee, sometimes called not-for-profits, but that is incorrect because every company has to make a profit. But these companies limited by guarantee, there are no shareholders, so there is no ability to distribute money every year. The money gets locked up in the company. If the company can't continue, it's passed on to another charity or body that does similar things, or you can distribute it back into the business, but you as the shareholders can't take it. You can take a salary, but you can't take the profits. Now clearly, if you're running a for-purpose company where that profit is going to be distributed to a worthy cause, that is exactly what you want to do, and that will also be much easier for you to raise money by way of grants or donations. But at the end of the day, if you want to run a business where you will benefit from the profit, then you need a PTY limited company. Obviously, there's nothing to stop you receiving that profit and then donating it to a good cause, but it means that you're in control of that process. Having done that, you should not let this company run without some rules and regulations. And there are essentially three documents which are going to govern those rules and regulations. The first one, which you should get when you incorporate the company, is what's called a constitution. This is no different to the constitution of a sporting club or a social club. It's the basic set of rules that govern how meetings are going to be held, how much notice needs to be given, who the officers are, all the fundamentals. Very boring, very tedious. Most people never read the Constitution until they have to go to court. Constitutions can be short, they can be long, but that is the fundamental agreement. And remember with the Constitution that it can be changed by a vote of 75% of the shareholders. So as you start to bring in more shareholders, you need to think about the balance of power in the company. That comes with the company. Typically, the Constitution is supplemented by what's called a shareholder agreement. And this is an agreement, and it is between the shareholders and the company. And typically, this agreement can only be changed if all the shareholders agree. And so in this agreement, you will find that more important, more personal things are dealt with, financial matters, who has the right to appoint directors, how the company is going to be managed, the voting control that some shareholders may have, which may be better voting rights than others, but all of this will be set out at some length in the shareholders' agreement. That agreement will differ in its structure depending on whether there are two shareholders with an equal vote, because if that is the position, then a lot of things do not need to be in the agreement, because either the two shareholders and therefore the two directors will agree or they won't. And the main issue is what happens if they can't agree. In the more common scenario where there are two or more founders and some investors coming on, then the document is a bit more complex, because you need to think through all the issues that can arise in the particular venture and regulate what's going to happen. And it's much, much better to do this when the relationship is at its start, when optimism is at the highest point. And what you're trying to do is to say that if something unfortunate or bad happens down the track, this is how we're going to agree to deal with it. It'll just make the process of dealing with that much easier later on. Now, the third agreement that is relevant between shareholders is what is called a vesting agreement. Now, I'll just divert a bit to talk about the process of vesting, and that means that you might get your shares on day one, but you agree that if something prevents you continuing the journey as a shareholder, you have to hand some of those shares back, either to the other shareholders or back to the company. This is a common technique that's used by investors to keep founders focused on running the business. And you will find, in fact, that even if you're 2 or 3 years into your business and you go and raise money from a company like Airtree or Blackbird, they will want you to start revesting. And so it should be viewed like a lockup of your shares for a period of time, and it commits you to working in the company against the risk of losing your shares. These provisions can be in the shareholder agreement, but because they're usually for a limited period of time, we much prefer to have them in a separate document, and for the rules relating to the vesting to be separately described. And again, the rules may change depending on the role someone's playing in the company, or whether they're part-time or full-time, whether they're a founder or a key employee. But they're the three documents that will form the foundation of the way your company is going to be regulated. And whilst there is a cost involved, because there is time spent identifying the issues that are going to possibly occur with the company and how they're going to be resolved, that is a good insurance policy to put away. And if you've done the job properly, when an investor comes on board, an investor, if they see a shareholder agreement that has been well crafted, will allow you to keep your shareholder agreement. They may ask for some changes, but you're not faced with having to look through an entirely new agreement, which will obviously be much more weighted in favour of the investor. So we do encourage everyone to spend some time at the beginning thinking about these things and getting those documents in place.